Hello and welcome to our webinar, Why Can't I Just Pay Everyone a Salary? My name is Julie Dorr and I will be your moderator for today's event. Our presentation will last approximately 40 minutes and with the remaining time available for your questions. Remember that you can enter, you enter your questions at any time in the questions section of your dashboard. Remember that's over on typically on the right-hand side, and just click that question tab and you can enter the questions. But we're going to hold answering those questions until the end of the presentation. Also, we provided you with a copy of the presentation, and it's located in that handout section. Just again, click on that tab and you can download that PDF right there. If you have any problems with that, just feel free to email me right now. My email is on the screen. It's julie@thedoorgroup.com, and I'll send you that document right away. Before we get started, though, please note that this webinar and all of the accompanying materials are protected by copyright, and that the entire conference is being recorded. This presentation provides general information only and does not constitute legal advice in any way. We recommend that you consult with your own legal counsel to address your specific situation. So let's get started today by welcoming our expert panel. First, we have our people problem solver, Linda Duffy, president of Ethos Human Capital Solutions. Linda works with business owners and executives to provide strategic human resources direction, develop leadership talent, and help you find the right employee while increasing your organizational effectiveness. We also have attorney Marla Merhab Robinson. It's always a tongue twister for me. Marla is with the law firm Merhab Robinson, Jackson & Clarkson, where she is a partner and head of the firm's transactional department. She primarily practices in the areas of corporate, mergers and acquisitions, real estate, finance, and employment law. Marla, I'm full of tongue twisters today, so I'm going to throw this off to you to get us started with the agenda. Marla, are you there?
Well, this is Linda. I'm going to jump in. I'm wondering if Marla is on mute or if something happened and she got disconnected. But I'll go ahead and jump in to keep it going until she gets back. So today we're talking about classification issues. Marla and I both come across this a lot in what we do on a daily basis. So it's really important that we are classifying people properly, whether they're exempt or non-exempt. And we're going to talk about...
Hi, it's Marla. Can you hear me?
We can now. Thank you, Marla. I was just trying to go over the agenda, but I'm going to turn it back over to you.
My apologies. I don't know what happened. I got kicked out, and when I kept trying to call back in, I got a busy signal. I finally got no busy signal, and then it kicked me out again. So everybody, I'm very, very sorry. So Linda started with our agenda. I just want to start with our title. Why can't I just pay everyone a salary? That's the question I get asked most often is, well, I put them on salary, so they're exempt. And that can be the case in other states, but that's not the case here in California. Actually, can't either in other states because you still have to follow the federal rules. But it's not the only test. It's only one of the tests. So our overview today is we're going to discuss specifically the professional, executive, and administrative exemptions. We're going to discuss the salespeople exemptions. There's two. And some computer professionals exemptions. There are some really unique slight exemptions that we won't discuss that don't apply to most of you. But if you think there's something, you can shoot an email to Linda or me after the webinar. We'll discuss potential liability, the new federal exempt salary threshold that will apply to us, even though it's greater than California's exempt threshold, options for compliance, and then if we have time, Q&A. This is kind of a lengthy webinar, one of our more lengthy webinars. So why is exempt, non-exempt classification so important? Firstly, that it's highly litigated both by individual employees on their own and by class actions. And the distinction is critical. It's one of the least understood areas of employment law. The analysis is fact-based and technical. And if you're unsure, even after we go through this webinar today, it wouldn't surprise me if there are times when you're unsure. Please seek the assistance of someone like Linda or an attorney like me or another attorney to go through the analysis together. And you may often find that even after we go through the analysis, we can't say for sure this person is exempt. We can only give an opinion. We think a judge or a jury or the DLSC or the DOL, these are the people that would be looking at it, we think that they would find them exempt. But because it's so factually based and you'll hear some of the terms that are not black and white that are used in the analysis, the legal analysis. Very difficult sometimes to make a definitive answer. Other times it's easy, and we'll go through those too. The litigation obviously is very costly. There's the potential back overtime pay for 3 or 4 years that would be due if the classification is wrong. There's high potential fines and awards when the employees are misclassified. One of the most common here in California is when an employer misclassifies as exempt, they then don't require the employee to keep time records. Well, that alone, if the determination is that the classification was wrong, that the employee is not exempt, is a first penalty. That you're fined for not keeping records that you were supposed to keep. So some employers require even exempt employees to keep time records, although they're not required under the law. They do so to protect themselves in case their classification has been wrong. Linda will speak to the new exempt salary requirements that were put in place by the Federal Department of Labor that go into effect December 1st, which increased the minimum salary from $41,600 to $47,476. She's going to take on the math portion of this for me. So let's address the concept in general, exempt versus non-exempt duties. Here's a list of non-exempt duties, not duties. In general, items that are different about exempt employees and non-exempt employees. Non-exempt employees are paid for all hours worked. They're paid at overtime rates for all work over 8 hours in a day and 40 hours in a week. They're paid more frequently, and they must be permitted to take meal and rest breaks. And they must record their time worked. Exempt employees, as I said, can record their time worked, but they're not required to. They get paid to get the job done regardless of the hours worked. They tend to often have to work many more than 40 hours a week. They're paid the set salary, which again is either the minimum or something higher, no overtime pay, and they're not required to take meal or rest breaks. Remember, titles don't matter. Simply calling someone a manager, for example, or one of the exemptions that we'll go through, is not going to be enough. We'll talk about what is enough, what those elements are. Again, as to the title of our webinar, paying a salary does not make an employee exempt. Don't assume that paying a salary makes you an exempt employee. The exemptions are very narrowly construed and must be looked at under both federal and state law. However, California law, as it is today, is much more restrictive than federal law. So we look more to the California test where we don't have some information. We can then look to the federal cases and the federal law for some guidance, because California is based initially on federal, but then it is developed to become more restrictive. The executive, administrative, and professional employees are specifically exempted by California law and federal law, and they're generally called the white-collar exemptions, and we're going to talk about them shortly. First, the monthly salary requirement under all the white-collar exemptions, that they must earn a minimum monthly salary of no less than 2 times minimum wage. Now that minimum wage has got to be the new federal number that I gave you earlier. Typically, exempt employees are 2 times minimum wage and paid either once or twice a month, depending on the type of the employees. They must receive the same predetermined amount each pay period, and it cannot be reduced because of variations in quality or quantity of work performed. With some very limited exemptions, exempt employees must receive their full salary for any week in which he or she performed work. Now, we've had a flip-flop with the Division of Labor Standards and Enforcement here in California. The rule used to be if you worked 1 hour a week, you had to be paid, you, an exempt employee, had to be paid for the entire week. We had opinion letters to that effect in that department that said that that was the case. They've gone back and forth on that issue. They're currently opining that you can deduct if the employee does not have vacation pay available if they don't work a full day. However, my recommendation to my clients is to never do that. It's not worth the risk of changing an employee from an exempt to non-exempt, and opinions are just that, opinions. They do not have to be required, accepted by the court. They're available for the court to look at if they want. They're supposed to give employers guidance on how that department would determine an issue, but it doesn't mean that a court or a judge or a jury would determine the issue the same way. So we err on the side of caution and recommend to our clients, if you have an exempt employee that worked 1 hour a week, to pay them for the week. Now, for some employers, that just doesn't work, and we will go through the analysis with them, but it isn't something that should be looked at globally. It should be looked on a case-by-case basis, and what the purpose of the day off is, whether it's vacation or something else. So for each of the professional, executive, and administrative exemptions, in addition to the salary element, or what we call the white-collar exemptions, in addition to the salary element, the second element is discretion and independent judgment. Most of the exemptions, the other exemptions also require this, and it's that the employee customarily and regularly exercise discretion and independent judgment. Well, what is this? It's a factual analysis that comes into play, and again, with words that are not easily defined, but the concept is that they have the power to make independent choices pertaining to matters of significance and free from immediate supervision, independently, on their own. Or they have the ability to make a recommendation for the action that is the superior's final authority, but their opinion is taken into account or into consideration when their superior is making that decision. They have to have enough credibility that they're not just making a suggestion that's never taken into the consideration. Think of the comparison of evaluating different courses of conduct and acting or making a decision after the various possibilities are explored, either independently by themselves or with someone else where their participation is taken as a real opinion. So let's discuss the first of the exemptions and the easiest exemption, and that's the professional employees exemption. I always go through this one first because you can knock out most of your employees here, unless you're in my profession. So licensed or certified by the state of California and primarily engaged in the practice of law, medicine, dentistry, optometry, architecture, engineering, teaching, or accounting. So if you're a licensed lawyer or a licensed doctor or a licensed dentist, you are exempt, again, if you meet those other tests, the salary test, independent discretion and independent judgment. So that's on here as well. Or is primarily engaged in an occupation commonly recognized as a learned or artistic profession. I'll talk about that in the next slide. It's a little bit more difficult. But again, remember, you've got to customarily and regularly exercise discretion, independent judgment in performance of the duties, and it's the duties tied to the certification, perform work that is predominantly intellectual and varied in character, and earn 2 times the minimum wage. It says state minimum wage here, but now it's federal minimum wage. We started with an old slide presentation and before the federal laws changed. So learned or artistic profession. This is a difficult one. I've had very few cases where this has come into play, but it's clear that it requires advanced knowledge in the science or learning field customarily acquired by prolonged course of study. Think of, for example, a BS in chemistry or BS in engineering that might not get rise to the level of a license, but it has specialized intellectual instruction. Remember, still must meet all the other tests that are on the salary and the independent judgment. Or on the artistic side is original and creative in character in a recognized field of artistic endeavor, as opposed to work that can be produced by a person with general manual and intellectual ability. Someone like me would not ever fall into the artistic profession, but some examples I can give you are fields of music, writing, theater, plastic and graphic art, but the work must be original and creative in character, and again, must meet that doing it independently. So a lot of times it depends on the invention or the imagination of the employee creating the work, that they're maybe commissioned to do something but not told how to do it. This is a very highly technical area of analysis, and again, it's one I've seen very few of. The second, next easy exemption, not quite as easy as professional because it's easy to determine who's licensed and who's not, is what's called the executive and managerial exemption. Under the wage orders, it's actually just executive exemption, but we use the term managerial because that's what it goes to. The primary duty is management of a business or department or subdivision. The manager has to customarily and regularly direct work of 2 or more full-time employees. What does that mean? That means they have the authority to hire, fire, promote, demote, recommend hiring and firing, and change of status. Or again, this is one of those areas where they can participate in the decision making, but their participation has to be real. It can't just be like a title that doesn't really mean anything. They have to customarily and regularly exercise discretionary and independent judgment, as we discussed before. They must have the minimum wage, 2 times minimum wage salary, as we discussed before. And most critical here is that they must devote more than 50% of their time to the activities above. This means 51% of their time. And one of the areas, if anybody would like to review this area, that happens commonly is in the restaurant business, and in particular to Del Taco and Taco Bell. You can type in Taco Bell exemption lawsuits, and you'll find several, unfortunately. But they would get in trouble because they call their managers key managers, and they do have all of these things: the authority to hire, fire, promote, demote. They're setting schedules for their employees, so they're managing the business. They're giving performance evaluations, also engaged in the management of the business. But what they found when the analysis was done, they were doing that less than 50% of the time. So they were selling tacos 51% or more of the time. That's not exempt duties. So if we go to the next slide, we can give some examples of things that are managerial duties or executive duties, and those would be the interviewing and the hiring process, setting and adjusting pay rates, directing work, keeping production of records, evaluating employees' efficiency and productivity, again, appraisals, disciplining, planning work, planning production, determining techniques, distributing work to others, deciding who gets what schedules. These types of things are what you would find as managerial duties. The types of duties that are not would be performing the same kind of work as subordinates. So while I might be managing people, if I'm also on a line of manufacturing and I'm doing that 51% or more of the time, that's going to be non-exempt duties, and that's going to take me out of the exemption. Performing production work unlike that, but which is not part of a supervisory function. So might be performing work that's not on the production line, but is not supervising managers. Again, if it's 51% or more of the time, you're going to lose the exemption. Making sales, replenishing stocks, again, those are not managerial duties. Performing routine clerical duties such as bookkeeping, cashiering. Now, some of those clerical duties, so for example, completing performance appraisal forms, might be managerial. So you have to look at those while you're doing your analysis. Some additional considerations to keep in mind is in emergencies, if an executive has to jump in because of an emergency, which can sometimes happen on a production line, that will not take, if it happens on occasion, it's not going to take away the fact that they're doing it 51% or more of the time, other than in a bona fide emergency. Employees in training for employment as executive are not exempt unless they're actually performing the exempt duties. So you have to look at that analysis differently if they're in training. The requirements of the state and federal exemptions often vary in their applications, even when the exemptions are found in both laws. Again, particularly here in California, because ours are more restrictive. So our next exemption, and I call these the top 3. Linda's going to go through some of the others once we get off the top 3. But of the top 3, the professional, executive, and now administrative, this is the most difficult exemption to meet. It's also the most difficult to analyze. We're still waiting for more direction from the California Supreme Court on this exemption. This exemption is for an employee's primary duty is the performance of office or non-manual work. So this is not going to be somebody who's on a production or manufacturing line, directly related to management policies or the general day-to-day business operations. So this is someone who actually makes business policy decisions. Think of someone who has an impact on company operations and substantial importance to management and operations. I can tell you what happens most often to me and where I see employers who want to find someone who fits is with bookkeepers. And it'll be a bookkeeper who is fantastic at their job, does an incredible job creating financial statements, accounts payable, accounts receivable, but they don't exercise any independent judgment. They don't have any business policy decision making. They don't decide if the company needs a new line of credit. They don't decide if the company is going to pay off creditors or not. That decision is made at a higher executive level. So remember, it has to have all these elements. Again, we still need the more than 50% of the time, so 51% or more, and earning still 2 times minimum wage. This is a very, very difficult burden to meet. So please, if this is an area where you say, oh, this person is definitely admin because they're not working on the business of the business, they're working on the management and policies, that's not enough. You still have to have the independent discretion, the independent judgment, and they still need to be making substantial contributions to the management and operations. Here's some examples of the duties. Advising management, planning, think strategic planning, negotiating, representing the company, purchasing materials and supplies, promoting sales. Again, some of these can get moved over to non-exempt if they're not done with independent judgment. If I'm in charge of purchasing supplies, but I only do it at the direction of my supervisor, that's not going to be enough, even if I'm doing it 100% of the day. Non-exempted duties would be routine clerical duties, my bookkeeper example, making deliveries, operating equipment, inspecting projects, and tabulating data. So with that, I'm going to turn it over to Linda.
Well, thank you so much, Marla. I'm so happy you did all the heavy lifting for us this time. As Marla mentioned, those were what we would refer to as white-collar exemptions. Those are sort of the big 3 that we all look at. There are a few other possible ways that someone can be exempt under the law from overtime, and so I'm going to just briefly touch on those. So salespeople. For the most part, outside salespeople are going to be able to be exempt, but there's a couple of key things that you need to know. And the second bullet you see here is really the critical one. Spends more than 50% of their working time away from the employer's place of business, okay? That also could be away from a home office. So just because you have them working out of their home does not mean that they're exempt, okay? That could still be considered an inside salesperson. So this is really designed for somebody who's out there traveling, who's like face-to-face with customers actually trying to sell goods or services. But again, more than 50% of the time, they have to be outside an office working with customers directly. And I told Marla this about 6 months ago or so. I went to a presentation delivered by a law firm, and they invited plaintiff's counsel in, and he even said he could make a case that nowadays your car is the same as a home office, and so just because you're out on the road doesn't necessarily mean that the person's selling. He tries to challenge that by saying how much time were they actually spending in front of a customer face-to-face. So just be aware that this applies to people that are outside selling face-to-face to customers, not sitting in an office, calling people on the phone. Now, we do have an exemption for inside salespeople that's a little bit more complicated, and this applies to employees working under wage orders 4 and 7. So wage order 4 is the professional, technical, clerical, mechanical exemption. Wage order 7 is for mercantile. So first and foremost, you want to make sure that your employees are going to fall, your business falls under one of those 2 wage orders. This gets more complicated all the time. We had some case law a couple years ago that came down that actually affected this even greater, but in essence, the high-level understanding of this is they have a couple of different requirements they must meet. So one is they have to earn 1.5 times minimum wage. The second part is more than half of their compensation has to come from commissions or variable pay. Okay, so more than half. So it's a twofold criteria that you have to take a look at for inside salespeople. Now, I had this come up with a client very recently. They thought they were complying with the law. They had their inside salespeople salaried greater than $41,600, which is the salary, as Marla told you, for the white-collar exemptions. That is not the rule for inside sales. So we had to go in. We took a look at how they were structured. We said, here are a couple of options. One, you can restructure their pay, lower their base pay, put them on commission, things like that. They knew that their employees were not going to be happy about taking a pay cut on their base salary. And they opted to go back and reclassify them, and that they ended up paying about $200,000 in back overtime, because they did have time records for the most part for that. So it can be an expensive mistake to make, so you want to make sure that you're always complying with the laws that apply for that particular position. The other thing to know about the inside sales exemption is they look at that on a weekly basis. So if in any given week the compensation does not, if the employee's compensation does not have 51% or more coming from commission, that will mean that they're non-exempt for that week and you need to go back and pay them overtime. Okay, so that's a pretty costly one if it's not done properly. There's another one for computer professionals. I'm not going to go into great detail about this. There's a lot of information on the slide you can look at. Just know that this one has a couple of other requirements to it, both in terms of how much independent discretion and judgment they have, of course, but also the types of duties they're talking about. I have a lot of times, my clients will say, well, I've got somebody that, he's our help desk guy or woman, and, I'm paying him over $41,600, and I say that's all great, but that's not the rule. Right? That does not fall under one of the white-collar exemptions. So in this particular instance, first and foremost, you want to take a look at the duties that are involved. And if you look in number 1 in the center there, you'll see it's applying systems analysis techniques and procedures. It's actually like designing, developing, testing systems, that kind of thing. So this is not designed to be for like general help desk, like they go and they fix your problem. As Marla pointed out on like bookkeepers, it's not a lot of independent discretion and judgment involved, and that's what you're looking for in this. They also have a completely different salary threshold. So for the computer professionals, it actually is indexed every year. So for 2016, you would need to be paying this person over $87,000 a year. So that's usually where we start, is how much is this person making before we even take a look at the duties test, because a lot of computer professionals are not making over $87,000 a year, at least for smaller clients. In larger companies, they might have some people in the IT department that fall under this exemption, but the vast majority will not, so you want to take a look at that. So I already mentioned a couple things for non-compliance. There's back pay, there's penalties, there's potential attorney's fees, and it's so important to know a couple things. One is employees cannot give permission to employers to break the law. Okay, so I have clients say that all the time. I have employees ask me, well, can I sign a waiver? Can I go ahead, because I'd rather be salaried exempt, whether it's because of ego or they don't want to clock in and out, or maybe their benefits are different. Can I sign a waiver? Can I enter into an agreement that says I'm exempt? No, you can't. Just like Marla said, it doesn't matter if they're paid a salary. It doesn't matter you give them a manager title. I have a friend who works in the assisted living type of industry, and she actually had her boss say to her, oh, well, I signed you the receptionist and I signed you this other person to report to you so I can make you exempt. Okay, doesn't work that way. So it's really important that you play by the right rules, you know which rules are the right rules, and play by them, because you don't want to end up going back and reclassifying people. The same client I just mentioned about the inside salespeople, it caused us to take a look at the rest of their employees as well. We ended up reclassifying 2 people in purchasing and also 5 people in their warehouse. This company has their main location here in Orange County, but they have 3 warehouses. They're a distributor. There's 3 warehouses throughout California in different locations. They only have about 3 or 4 employees in each of those remote locations, so they have like a warehouse leader, a warehouse supervisor. But when I started drilling down, okay, how does that person spend their time? How much independent discretion and judgment do they have? Are we trying to classify them under the executive and management white-collar exemption? Well, how much of their day is spent doing managerial things? And the answer was very little. They might get involved in hiring. They schedule their people, but everybody's scheduled the same hours every day. They have a little bit of input on performance appraisals, but every day they go in and they work side by side, picking and shipping orders just like the people that report to them. So for this company, we went back, we reclassified a couple of purchasing people that were more just order placers, reclassified 5 warehouse people, 6 or 7 inside sales people, and altogether they ended up issuing checks for about $350,000. So I don't know how many of you on this call have extra $350,000 laying around, but it can be expensive if that is, if that mistake's made. You also have to remember, like Marla said earlier, all we can do is do that analysis and tell you, issue an opinion about what we think is going on there, but there's no guarantee that that classification is going to be recognized or agreed to by the courts or by the DLSC or by anybody else that comes in and does that analysis. So unfortunately, it's so subjective when you're trying to apply these different standards. So we go in, we try to do that analysis, we document exactly where the employee says they're spending their time, and usually check that with the manager to say, yes, that's in fact where the employee does spend their time. You might even have them do a time study or something like that, so you have some records to back yourself up. So as Marla mentioned, and one of the reasons we chose to redo this particular presentation or update it and redo it now is because effective December 1st, there is a new rule that goes into place. So up until now in California, we've always played by California standard because it's always been that much higher than federal law. The federal salary, minimum salary, has been $23,000 forever, literally like 50 years or so, and so they just changed it this year. It's scheduled to go up December 1st, and the new standard salary for white-collar exemptions will be this number, $47,476. So what you need to do is make sure that anybody that you have exempt under the white-collar exemptions, again, the administrative, professional, and executive, is at that salary. There are a couple of caveats we don't have time to go into. I will remind you that in July we did a webinar on this particular new law. So go out to our YouTube channel. You can just search Ethos HCS, or Marla has one as well, and you'll see our webinar posted there. Okay, so go through that. It'll go through a lot of the differences. This is about $6,000 a year difference. So for some companies, it's going to be pretty significant. All right. Here's where it gets a little crazy, and again, who knows? There's been legislation that's been introduced to push this implementation off by 6 months. It's passed the House. President Obama has indicated that he's going to veto it. The Senate is trying to pass a bill as well. There's been a lot of conversations. We'll see whose lobby is stronger, I guess, in the next month or so, but we're recommending that everybody be prepared to make this change effective December 1st. The page that you have in front of you is actually from Cal Chamber, and what's a little crazy making is that every year you're going to have to take a look to see who has the higher threshold to meet, the higher burden to meet. It's going to differ by the number of employees you have, and it's going to differ by year, because anytime one of these laws gets passed, it gets, and there's a salary set, it gets indexed, meaning they're going to review it, or they're going to say every year it goes up by how much, just like I said for the IT professional. So in this particular instance, we know going into 2017, employers that have 26 or more employees, the minimum wage is going to go up to $10.50 an hour, which means now you're going to have to be 2 times that, so you can see the number is going to be $43,680 a year. But then you look at the federal threshold, and if the law goes through, that's going to be $47,476. So in that case, you go, what's the higher standard in benefit of the employee? And you're going to say it's the feds. But you jump down a couple of years. Now, as our minimum wage goes up, and it's indexed to go up every year, at some point in time, we're going to cross paths with that federal number, and then the burden is going to be higher for the state. So in 2019, just to make your head explode a little bit, it's going to depend whether or not you have more than 26 employees, or if you have 25 or less employees, and you're going to have to look at that all of the time. Okay, so good luck with that. Marla and I are here when you need us, but this is going to be really tricky for the next couple of years as all of this sort of gets settled out. So let's talk about what you can do, some options for compliance here. So obviously one option is just to raise the salary. You do an analysis, you take a look at the people that are under that 47,476 number, and you go ahead and raise the salary. You obviously need to be concerned about budgets. You're going to need to be concerned about salary compression, wage compression, because it depends. If you raise them, what about the people that right now are salaried at, $48,000? You've just bumped people $6,000 a year, so you're going to have some issues there. It could potentially be less administratively burdensome if you stop having them track hours and stuff, so that could be a positive. It certainly is going to help with morale, but there are some offsetting concerns there. Similarly, you can also just choose to make them non-exempt, pay them hourly, and pay them overtime. So if people are borderline, make sure you have them keep their time. Also remember that overtime has to be paid on the regular rate of pay. So if you are paying people any sort of bonus, commission, something like that, that has to be calculated in with the regular rate when you calculate their overtime. that could potentially increase costs for employers. You want to take a look at that. It could increase risks if the hours aren't properly tracked, and also it could be a lower morale because of loss of benefits or just ego status of no longer being salaried exempt. But if the employee makes more money, if they're right now working a lot of overtime and they're not getting paid for it per se, they feel like they're not getting paid for it, it could be a boost to them, right? But again, that's a budgetary issue. The third option is to reduce or eliminate overtime just by hiring more people. Again, you're going to take a look to figure out the budgetary aspects of that. You can also convert them to hourly by dividing by 2,080 or coming up with some sort of rate that when you factor in their overtime is going to be close to what they were making before. You can always restructure the jobs to be exempt. If somebody's doing some things that are, maybe you have a couple of employees that are doing certain managerial items, you could take some off of one person's plate, put it on another, so that person has at least 51% of their time doing management-related things or professional or administrative, whichever one. Typically, I think of that as management-related, and just shift some duties around and reclassify people. Now, we're not going to go into detail on this. There is the ability to use bonuses and catch-up pay, so you can use 10% of that number, so roughly $4,700 in the form of a bonus. If at the end of the year they have not achieved that bonus, though, you are still allowed to make a catch-up pay to get them to that salary. But you want to make sure that you're very careful when you implement that type of practice. Consider alternative work weeks. That might be a way to get around overtime. We see this a lot in manufacturing. You want to check your IWC order to make sure what options are available for alternative work weeks, and we can help you implement that if you need help with it. But that might be a way to restructure the work week to say, okay, now we're going to put everybody on 410s, for example, eliminate a day a week, and that way you don't end up paying them the overtime for those 2 extra hours. And then of course, you can always outsource this work or find other ways to get it done. Marla mentioned that they'll do this as well. We actually offer an FLSA audit. We've been getting calls from people that need help with this implementation, so if you're interested in talking with us about how we might help you with this transition, by all means reach out to us sooner rather than later, since we now only have about 4 weeks until this is going to go into place. And we actually got through that material faster than I thought we would, Marla, so I'm going to turn it back over to Julie to take some questions and answers.
Well, great, ladies. Thank you so much. This is a tough topic. I know when I talk to some of my clients, they're scratching their heads, what does this mean? And it seems like we have to hear this a couple more times for us to kind of have it all sink in. So what we're going to do right now is basically open up the lines for questions. We're concluded with the presentation, so what we want to do is ask, and I know some of you are already sending some emails in as well as putting in the questions in the chat. How to do that again? Go ahead and click that questions tab, type in your question. I'll read it aloud for both Marla and Linda to answer. And let's get started right away. We've got one here from Trish. Would certified massage therapists be considered a professional employee? Is that a learned or artistic maybe possible?
I was going to say I'm going to pass to Marla if she's not there.
I'm here.
Okay, I was going to say I don't believe so, but Marla, what's your opinion?
No, again, primarily the wage order is primarily engaged in the practice of law, medicine, dentistry, optometry, architecture, engineering, teaching, or accounting. I don't think it would get up to the level of the learned profession, because that's generally in the same types of professions. For example, an accountant who is not a CPA but is waiting for a CPA result, or a law grad who's waiting for bar exam results. In years past, the courts did not even hold them as learned professions. In recent court cases, they have. It's generally got to be a more advanced type of education, specialized intellectual instruction, is generally tied to science or a learning field. So no, I'd say no.
And
Okay.
let me just add one other thing on that. Also be really careful with massage therapists, nail salons, all those type of industries that people are classified properly as employees versus independent contractors. We've had a couple of instances, a couple of clients where they got tagged pretty badly, in one case by Employment Development Department, because the way they had set up the compensation and the rules of engagement, so to speak, with that company, they had them classified as independent contractors, but they really were not set up that way at all. And so they had to go back pay, back taxes, and then convert them all over to employees. So those type of industries I get concerned about just in general, making sure that, that they're being classified properly from that standpoint.
Good point.
And
Okay,
I can add, Julie, let me add for the person who asked the question that the proper wage order for that is wage order 2, I believe. So if they want to look up the wage order and confirm what we were telling them, they can do that.
Okay, great. Thank you very much. Moving on to the next question, and you may have covered this in a previous webinar, but I'm going to ask the question anyway from Crystal. How do we analyze a salesperson to be exempt or non-exempt?
So I would direct you back to that slide that I went over. So there's a slide a few slides back that talks about outside salespeople and inside salespeople. And the outside salespeople, you need to be spending 51% of your time out in front of customers, okay? So away from an office, whether that's a home office or your office. And as I mentioned, you have to be careful because plaintiff's attorney told me, he even concerns, thanks Julie, he even considers a car to be an office these days because you can use your phone's a computer, you can make phone calls or whatever. He's looking how much time is face-to-face with customers. So that's for outside salespeople. Inside salespeople, again, you need to make sure that you're covered under one of those 2 wage orders, wage order 4, professional, technical, clerical, or wage order 7, which is mercantile. That's the first rule. And then the second thing is you have to make sure they're compensated appropriately, meaning they have 1.5 times minimum wage and that more than half of their compensation comes from commission. Now, we weren't going to go into detail on this, and I'm going to ask Marla if she wants to jump in here. But my recollection also is from case law that came down last year, the year before, if you're paying people, you cannot use the commission to meet that 1.5 times minimum wage unless the commission's paid in that pay period. Meaning when you're looking at it week by week to see did they get more than half of their commission or half of their compensation in the form of commission, but you're only paying commission once a week, you need to make sure that they're earning that 1.5 times minimum wage in and of itself without applying the commission to it, if that makes sense. It's a really complicated situation with inside salespeople, so definitely reach out to one of us.
And she's correct. That was a case last year or the year before. It has to be allocated to pay periods in which they're earned, and it's a Time Warner case if anybody wants to look at it.
Okay, great. Thank you so much. Melody had a question about how do individual city-county minimum wage requirements, such as San Diego and LA, fit in when you talk about 2 times the state minimum wage?
Linda and I were talking about this the other day. When you're talking about the minimum wage you have to pay someone, if you're in one of those cities or counties that has their own minimum wage requirement, to meet the minimum wage requirements, you have to pay that. But here we're talking about exempt, and remember it's a salary. So you have to meet the higher of the state or federal salary requirements. So once you've met that, you calculate their hours, and you should be fine with the city or county because you've got them on a salary, not an hourly.
Let me clarify this, Marla, and please correct me if I misstate this. So if somebody's hourly, you're going to need to make sure that you're paying the higher minimum wage. So let's say, as an example, California has $10 an hour, but you're in LA County and it's $10.50 an hour. Hourly people have to be paid $10.50. For exempt salary requirements, it's 2 times the state minimum wage. So in this case, it would be $20 an hour times 2,080, which gets you to that 41,600 number. Is that correct, Marla? Did I say that right?
Yes, until the federal rules.
Until the federal, right, so until the federal guidelines. So if the person's asking the question, do you have to be 2 times $10.50 an hour in salary? The answer is no, you have to be 2 times whatever the state minimum wage is.
Okay. Melody, I hope that answers your question.
Yeah. Until,
okay.
If not, shoot me an email or give me a call and we'll go through it. But yeah, so again, remember that chart. You're going to be constantly looking at what's the higher salary threshold for the white-collar exemptions. It's always been California, and it's about to become federal. So you're always going to be looking at that now going forward, say which is which. And it could change during a year. It could change probably each January. You're going to have to take a look at it.
Okay, good. Glad you guys are on board here. I'm like, oh, David asked a great question. If it's determined to convert current salaried employees to hourly, what is the recommended notice or time frame you would suggest? You know, and what are the other factors to consider, like morale? You know, you certainly got some issues with people wanting to be considered or wanting to be salaried instead of hourly.
That is a great question because, I mean, this is what we come up against all the time when we make that. So, you know, I don't believe that there's any requirement that, I mean, you could walk in tomorrow and change somebody's pay in theory, right, subject to not being under contract or union, you know, a collective bargaining agreement or something. So I'm not so worried about any sort of requirement to give them notice, but there are a lot of complicated issues here because like I mentioned, how is it going to affect the rest of your employees? Forget for a second about the people who are currently salaried that you're going to maybe change over to hourly or something, but if you decide to bump people up in salary, what happens to the person that's been making $48,000 and now they've got somebody making $47,000 where before you had about a 15% spread? Now all of a sudden you have a wage compression issue. That happens every time minimum wage goes up, right? I've got people I'm paying $10 or $10.50 an hour to. Now it goes from $10 to $10.50. What do I do with those $10.50 people, my $11 people? So I think you definitely have to take a look at all of those issues. What we did in the case of this client recently is we just sat down with them. We said, look, you know, here are the options we looked at. We want to do right by you. We're making this pay, but from now on going forward, this is going to be, you know, your hourly rate. We just simply took the salary and divided by 2,080. We didn't take into consideration, you know, the overtime. You could do that potentially. I think that's a big morale issue, but we just took it, divided by 2,080, said you're now hourly, you're going to clock in and out like everybody else. In this case, it didn't change their benefits in any way, so that was an easier sell. But they had to start clocking in and out, and the hardest situation for them, to be honest with you, you never know what it's going to be. But in this case, it was a group of women that had been with the company for a long time working in inside sales, I mean 15, 20 years. They like to come in early, grab a cup of coffee, and sit around and talk for like 45 minutes. And we had to tell them you can't do that anymore. We cannot have you on the premises. We don't want you working. We don't want you coming into the work area because we didn't want them to come back later and say that they were working when they weren't. We told them they could only clock in. We have like a plus or minus 7 minutes rounding on the time clocks. We said you can't clock in before that because we're going to have a time record that says you were here at 6:30 when really you start at 7. So that was something we, you know, had to sort of work through. But we just sat down with each one of them. We showed them the calculation. We told them why we were doing that, and we moved forward.
Okay. Marla, did you want to add anything to that?
Yeah, just a couple things. One, Linda's example is a perfect example of every company is different as to how you address it, because you first look at why you're addressing it. Some companies actually say, I'm putting everybody on hourly. I don't want to deal with whether or not I'm properly classified or not properly classified. I'm just not going to let anybody work overtime, or I'm going to watch it really closely, because that's that company's culture, and that's what that owner, maybe small owner, wants to do. For a big company, that might not be practical. So you have to look at every company on a case-by-case basis, like what's the best thing for this company. With respect to giving notice, whenever there's a change, even a change that is correcting what might be incorrect law, like you might have misclassified, and we know you've misclassified because we can do an analysis that's easy. We give a pay period's notice, because remember, you also have to post your pay periods. That is a posting requirement, not a notice requirement. But we always recommend that you do that, so that if you do have people who don't like it, they have an opportunity to leave, and that's generally, you know, adding a little bit of exposure for the period of time you may have misclassified, but not a lengthy one. But to Linda's story, every company is different on how you need to sit down with a professional, whether it's an HR consultant or an attorney, and say, here's the analysis, here's what we know we've got wrong, here's what we know we've got right, what are we going to do going forward?
Yeah, and that just triggered one other thing that we should have put on that slide. Remember also, if you're going to convert people from exempt to non-exempt, you need to issue them a wage theft notice. the 2810.5 Labor Code section where you have to tell them when they're hired or when any of that information changes, you need to give them a new sheet. So I just made a note, I have to ask that client, did they do that? So make sure also, and if you don't know what I'm talking about, let me know, but you have to do that for all non-exempt people when you hire them at any time their pay rate changes or workers' comp changes or the sick pay policy changes, anything like that, their address changes, meaning the company's address. So just make sure that if you do convert them to hourly non-exempt, that you make sure you issue them that notice.
And I think leading on to that a little bit, Jessica has a question which kind of follows along with this, and I think you probably want to do a little deeper dive in this. If you discover an employee should have been non-exempt and you switch them over, how do you approach overtime, meal breaks, rest periods that they should have been paid for in the term of their employment? For example, if they worked for the company for 5 years before the error was discovered, do you just go ahead and pay them, go back and do retroactive pay? Or is there some other extensive analysis and calculation that you should be doing?
Yeah, that's a great question. I'll tell you what we did for this client, and then Marla can jump in. So if there is a dispute as to how much time you owe them, then you can negotiate some sort of settlement with them. What we did in the case of this client is we had time records for the bulk. We went back 3 years and we had time records for the bulk of that time. So we knew when they clocked in and out for lunch, everything else, because they were doing that for the most part. We also had a period of time that we did not have any records for. So what in this particular instance we did is we went back and we said, okay, they were clocking in and out for lunch, so we know how much they took. We just calculated their overtime. We extrapolated an average amount of overtime per day for the period of time that we didn't have records, and we called it a day, and that's the number we went with. For a couple of the employees, they had not been clocking in and out for lunch, and so we sat down with them. We said, on average, are you taking a lunch? Yes, no. We verified that with their manager, and we just estimated it, and then again came up with a number. We essentially offered them a settlement for a potential claim they had against the company. So there's a document that Marla has that we used. We put that together. We had them take a look at it. We showed them backup. We were very transparent about everything with them. Every single person signed it, and then we issued them a check.
Okay. Marla, did you want to weigh in too?
Yes, and we've done the same many times, but as a broader answer, I would say we sit down with the owner of the company or the decision makers, whatever level they're at, and advise them of their options. We tell them if they've been breaking the law and you do nothing other than switch them. Sometimes employers get suspicious and say, I must have a claim, and they go in and file a claim. If you don't have records, it's very bad, as I said earlier, because you've already got one violation, the failure to keep time records on someone you were supposed to. I will tell you that when employees go in and make these claims, they go to the DLSE check-in, and they're asked, write down what hours you work, and 9 times out of 10 they write 8 a.m. to 8 p.m., 8 a.m. to 8 p.m. every single day. And the reason they can do that is because the law says whatever they say it is, if I don't have the records to disprove it, that is accurate. And my records have to either be time records, or sometimes we can show security cameras or computers where they're clocking in and out. But the law deems whatever they say to be correct because we made the mistake, we being employers. I don't represent employees, so whenever I say we, I mean all of us employers, myself included. But it's that, again, it's a case by case. There's no one answer that fits every company here, because different owners are different risk takers, and so I just want to tell them we just went through an employment audit. Here's our new handbook. Here's all of our new documents. And by the way, we've been told you guys need to move to hourly. Your duties are not changing. A lot of it's in spin and how you present it. Others say, I want to get the best release I can, as Linda just discussed, estimating. I'm going to estimate based on what I know our work hours are, what I think people have done. And sometimes employers, I just had this happen with a company that I represent. When we did their analysis and told them that they had misclassified, they knew the hours everybody worked. They didn't have time markers, but they knew the hours. So we did it based on that and then threw in a little bit extra. The problem with this is obviously it's an enormous expense often, because you've got to go back 3 years or 4 years. And if you're really conservative, you go back to 4 years.
Right. And again, like Marla keeps saying, I'm going to say the same thing. Every case is different. This particular employer wanted to be completely transparent about it. If you're reclassifying people because of the change in law, just tell them it's going to be all over the news. People probably heard about it when it first passed. They're going to hear about it a lot the week of December 1st, and just tell them this is why you're doing it. You're not going to owe them back pay because you weren't necessarily improperly classifying them. The reason you're changing them now is because there's a law, and you don't want to pay them the $47,476 for whatever the reason is, right? And there's legitimate business reasons for not rushing out and giving everybody a $6,000 a year increase. So I think it just depends on the circumstances. If you're reclassifying somebody because you feel that you've been, improperly classifying them, you might be able to take advantage of just doing it fresh on December 1st. You will have that outstanding liability. Again, some of my clients want to be transparent. Some want to stick their head in the sand and just hope they don't get a claim filed against them. Every client's different.
Well, unfortunately, that is all the time we have for questions. But I do want to point out one thing very quickly. Some of you have asked about the handouts. They are attached as a PDF to your dashboard. So if you look over in your dashboard, there's a tab that says handouts. Just click that plus sign, it'll expand, and you'll be able to download your handout right there. So Linda, we've got an exciting webinar coming up, so I'm going to let you kind of take us home here and finish up for today.
Great, Julia. Thanks so much, and thanks for doing a great job moderating as always. Because of the holiday schedule, we decided we're going to have one final webinar this year. It's going to be on December 8th. There is a new Form I-9 being issued. Everybody knows that the current one actually expired earlier this year, and we've just been continuing to use it. They have announced that they're going to be issuing that, I think it's like November 22nd or something. It's going to go into effect, I think, the first of the year. So we're going to go ahead and talk about that at the next webinar. We're actually reaching out to an immigration attorney to see if she wants to join us, so we'll get back to you on that. But here's the thing. Every single time I go out and do an audit, and we do a lot of audits of our clients, I have never, ever once found an employer who is completing the I-9 forms correctly. There are always mistakes. So we are going to walk through, we were going to do this anyway, and then we found out there's a new form, so it's perfect timing. We're going to walk through the common mistakes that we see when it comes to filling out the I-9 forms, because every single employer has to do this, so we hope that that's of value, and it's working out well that we'll have the new I-9 form to demonstrate on. So join us for that, and the registration link is right there.
I just add that we're supposed to have that form by November 22nd, and it doesn't have to be used until January 21st next year. So we should have plenty of time. Unless the new form doesn't come out, then we might have to send an update.
Which has happened before. Remember to register, though, because you can click on the link right now, but register now because we're limited to only 100 folks, and we've been tapping out, so I don't want you to miss this great webinar. All right, well, and everybody, thank you so much for attending. Linda, Marla, as always, great webinar, and I hope everybody has a great day today. Thanks. Thanks, everybody.